Court should be. We start on time, for the judges in the House anyway. Welcome to the Bail and Release Review Commission. I'm Aaron Freeman. As I was jokingly saying, Representative Jeter had a court appearance this morning, so here I am just carrying the water, brought Senator Poles, stuck in traffic, like, you know, here we go. So gonna do the best I can to do the best Chris Jeter impersonation that I'm sure will not happen, but I'll do the best I can until he gets here and brings some law and order to the place. Thank you for being here. The Bail and Review Commission was established in 2024. It was now codified in 5/2/25. You have in front of you, we did this last year, in case you don't recall. We had some recommendations, and this is the second year of that process. So thank you for a multi-year commitment to what you're doing. Could we go around the room and make sure your microphones are on, just so somebody watching from the public will know who you are? And how about we let's start with Judge Spitzer. Let's start there and then go around the room and work our way backwards, if that's all right. So you've got a green button on your microphone that you got to hit, or make your mic go green, and then you're good.
Okay. Thank you. I'm Judge Mark Spitzer. I am president of the Indiana Judges Association. I'm also judge of Grant Circuit Court in Marion, Indiana.
My name is Daniel Glass. I am a division director for the State Budget Agency.
Sheriff Dan Mayward, representing Adams County and the ISA.
Good morning. I'm Chris Goff. I serve as an associate justice on the Indiana Supreme Court, and I'm Chief Justice Rush's designee to chair the Justice Reinvestment Advisory Council.
Matt Pierce, State Representative for District 61, which is most of the city of Bloomington.
Good morning. Howard Sims, Executive Director for Division of Mental Health and Addiction.
I'm Betsy Baxter, and I'm the Director of Victim Services in the Madison County Prosecutor's Office.
Morning, Deputy Superintendent Al Williamson, Indiana State Police.
Good morning, Chris Blessinger, Deputy Commissioner for the Department of Correction, here for Commissioner Arnold today.
Good morning, I'm Prosecutor Jared Holtzclaw from Greene County, Indiana, and I'm here representing the Indiana Prosecuting Attorneys Council.
Larry Hessen, Hendricks County Counsel, representing the Association of Indiana Counties.
I'm Zach Stock, Legislative Counsel for the Indiana Public Defender Council, also an appellate public defender for the great county of Hendricks County.
My name is Philip Lashutka. I'm Deputy General Counsel to the Office of the Governor, Mike Braun, and thank you for everyone's attendance.
Well, tell us who you are. Come on.
My name is Chris B. I'm the Director of the Justice Services Division at the Indiana Hospital Services.
All right, anybody else? Bernice, I see you back there. Somebody's got their microphone on, so we just make sure it's off. Let's try that again. All right, I think we're good. Okay, well, again, thank you for the time. We have two meetings set, this one, and then if you look at your agenda, October 29th at 9 a.m., we will reconvene. So the way Representative Jeter and I envisioned this was to have a meeting today, have a robust dialogue, have three presentations, I believe, have robust dialogue on those presentations, and then we need some time to make recommendations. So let's get through today, and then recommendations that you have, suggestions you have, we'll figure out who the center point is, who we send those recommendations to, your thoughts and concerns, those kinds of things, and then we would put together a meeting for the 29th of October to discuss those recommendations and ultimately adopt something very similar to what we did last year. I'm sure, as most of you know, we are going through a multi-year process to potentially change the Indiana Constitution on bail. That would have to go through the General Assembly this coming year and then be on the ballot for November of 2026. And assuming that happens, assuming that happens, and if you assume something in the Indiana General Assembly, you have made your first critical mistake. However, assuming for this conversation that that would occur, I think it's probably a good idea to give our judges some direction in terms of put some meat on the bone, so to speak, as to what this means and what we would like them to do. So that's why I'm committed to the process and appreciate everybody's input. So are there questions or concerns or comments before we start? So Jared Holtzclaw is the prosecuting attorney in the 63rd Judicial Circuit. I like to remind people we are a judicial circuit situation, and I'm reminded of my dear friend Aaron Negengard, who tells me all the time that he is a judicial circuit and he's got 2 counties that he's responsible for. So I don't know how he got that lucky, but Jared's from Greene County and representing the Indiana Prosecuting Attorneys Council. So Jared, do you want to come? I would say probably go to the, yeah, go there. Just make sure you turn your microphone on, and thank you for doing it. I'm going to let her show you.
I was going to say, I didn't see a button, so. Testing. All right. Thank you. Oh, you're fine. All right. Well, make sure that works. All right. Good morning. I am presenting on behalf of the Indiana Prosecuting Attorneys Council. This presentation will describe IPAC's proposed implementing language for the anticipated amendment to Article 1, Section 17 of our Constitution, as set out in Senate Joint Resolution 1. As I discussed last year about this time, the amendment is responsive to a legal landscape that, in our opinion, is out of balance. Senate Joint Resolution 1, Article 1, Section 17, as a reminder, reads, offenses other than murder or treason shall be bailable by sufficient sureties unless the accused poses a substantial risk to any other person or the community. Murder or treason shall not be bailable when the proof is evident or the presumption strong. An offense other than murder or treason shall not be bailable if, 1, the proof is evident or the presumption strong, and 2, the state proves by clear and convincing evidence that no release conditions will reasonably protect the safety of any other person or the community. In our opinion, this balances out Criminal Rule 2.6's primacy of reappearing for court as the goal by specifically including substantial risk to any other person or the community to the Constitution. That is, it establishes a balance for both offender liberty and public safety. To be clear, Senate Joint Resolution 1 is neither independent of nor a repudiation of Indiana's current bail reform. Similarly, it is not a rejection of Criminal Rule 2.6. Instead, it is simply another tool for courts to use when appropriate. There is, of course, some variance from current law with the implementation of Senate Joint Resolution 1. First, current law does not allow for complete denial of bail when an offender is charged with something other than murder or treason. Second, current law and practice seem to reflect that public safety is not a co-equal consideration or purpose of pretrial detention decisions, but instead is rather secondary to guaranteeing appearance at trial. And third, it would allow for the denial of bail for pre-charge or pre-bail actions, which currently bail can be revoked for conduct occurring after bail is set and after a hearing is held. It has been assumed that this is constitutional under Article 1, Section 17 to do so, that it is not a criminal punishment as opposed to a public safety regulation, which was held in the Wilcox v. State decision. but a court cannot completely deny bail except for murder or treason for conduct occurring before bail was set. And that's what the Senate Joint Resolution 1 is set to correct. The General Assembly and Governor have already started to enact statutory changes consistent with the spirit of Senate Joint Resolution 1. For example, this past session, Senate Enrolled Act 324 added Indiana Code 3533-8 3.4, which directs that arrestees for crimes of violence or those who are repeat violent arrestees are to be detained without bond until a hearing is held by the court to set bail individually and in open court. So in terms of implementing language, the system would be best served by the General Assembly enacting trailing language to implement Article 1, Section 17, as would be amended, to set out to codify the law on the burdens of proof, the defendant's rights to counsel, cross-examination, the presentation of evidence, and the appeal process, and also the procedural steps required to invoke the amendment. The following proposals are based upon a review of existing Indiana law and also similar concepts set forth in the United States Code and in the statutes of the state of Illinois and the state of Ohio. I'll be covering these three statutes and the changes that each require. First, Indiana Code 3533-8.2 will need to be amended to incorporate the expansion of Article 1, Section 17, and to clarify the various burdens of proof. Currently, Indiana Code 3533-8.2 is the foundational trailing language of the now existing Article 117 language. The amendment of this statute will reflect the substance of Senate Joint Resolution 1 as passed by the legislature and voters, again, as Senator Freeman mentioned, that we assume will happen. Next, we're going to look at the proposed new statute, Indiana Code 3533-8 3.7, that will define the procedures used to implement the change to Article 1, Section 17. To begin, Section B states that a request for the denial of bail can be made by the state or can be initiated by the court on its own motion. And we'll take a look at that language now. You'll notice subsection A just merely iterates that this section doesn't apply to someone charged with murder. Those current existing protocols will still be followed for murder cases. I suppose it could be for treason. I still haven't seen a treason case filed, although if you follow Twitter, that word's thrown around quite a bit, so maybe we will see one. But this just reiterates that murder is still treated the way it is today. Subsection B sets out that the state will file a motion at or before the initial hearing asking for an arrestee to be denied bail. And it also allows for a motion to be filed at a later date if the state has new information that was unknown or unavailable at the time of the initial hearing. Our proposed statute will require a prompt hearing, which is necessary due to the fact that we are requesting to deny somebody their liberty until the case is resolved. And I believe it's subsection C that will cover that. That language dictates that hearings will be held as soon as practicable, with limitations on the continuances that can be sought. A defense continuance will be no longer than 5 days. A state's continuance could be no longer than 3 days. Subsection D codifies the essential defendant rights, including the right to counsel, the right to testify, the right to present evidence, and the right to cross-examine witnesses. The right to counsel does include the right to appointment of counsel if the defendant is indigent. There would, in our proposal, there is one small limitation to the right to examine a witness. I'm going to cover that here next. And this was taken from the Illinois statute governing preventative detention. A defendant could not compel the victim to testify without the court finding that justice would require it and that the defendant would be materially prejudiced if the victim does not appear. Examination of a victim for purposes of just impeachment would not be sufficient. It's our thought that the focus of the hearing should be on the defendant's suitability to be released on bail, not harassing the victim or permitting a deposition-style inquiry. Next, subsection F talks about the fact that, or establishes the fact that strict rules of evidence would not apply. Indiana Rule of Evidence 101D2 already establishes that the rules of evidence do not apply in bail proceedings. The statute would echo that and also echo that consistent with Criminal Rule 2.5, the discovery would not be compelled at this early stage of litigation. Next, we'll talk about subsection G to clarify that being detained without bail under the two relatively new statutes here, which are 3533A 3.4, which requires those people who are arrested for violent offenses or who are deemed repeat violent arrestees have to remain held until their initial hearing, and also Indiana Code 3533A 6.5, which requires those persons arrested for crimes, certain crimes, statutorily designated crimes involving family or household members that cannot post bail until initial hearing. Those particular people do not have a different set of rules. They would fall under the same set of rules that are set out in Indiana Code 3533A.7. It does not change the procedure or burden of proof if they were already held without bond because of one of those two statutes. I want to mention initially here, there was a typo I didn't catch before we submitted this. The second sentence reads, a court may order a person to be denied bail only if it finds that the proof is evident and the presumption is strong. The word and should be or. It needs to be consistent with the language of Senate Joint Resolution 1. So I didn't catch that on my review before it was submitted, but obviously we want to make sure that the language we use in this statute is consistent with SJR 1. But again, the Indiana legislature and governor already made changes to this chapter of the Indiana Code in many important ways, including those two statutes I just referenced, which hold certain arrestees without bond until their initial hearing. But this implementing language should ensure that court must make findings independent of those circumstances, meaning they would be treated just as any other defendant would be at this stage of the proceedings. An important role of implementing language is to provide guidance to the practitioners and the courts about what is meant by the constitutional language. This includes providing a list of factors for the court to consider in determining whether the defendant should be denied bail. That is set out in subsection H, and the facts that should be considered by the court include the nature and circumstances of the offenses charged, including whether the offense is an offense of violence or involves the use of alcohol or drugs, the weight of the evidence against the accused, the history and characteristics of the accused, including without limitation, the character, physical and mental condition, family ties, employment, financial resources, length of residence in the community, community ties, past conduct, history relating to drug or alcohol abuse, and criminal history of the accused. It would also include consideration of whether at the time of the current alleged offense or at the time of the arrest of the accused, that the accused was on probation, parole, community corrections, or release pending trial, sentencing, appeal, or completion of the sentence for the commission of offense under the laws of this state, another state, or the United States. It also would require consideration of the nature and seriousness of the danger to any person or the community that would be posed by the person's release. This language was borrowed from the Ohio statute governing preventative detention. Next, evidence and findings are treated similarly to Criminal Rule 2.6 assessments. And what I mean by that is no evidence or finding from these denial of bail hearings is admissible as substantive evidence at the case's trial. It only could be admitted for impeachment purposes or in the prosecution for perjury. Also, it's clear, or it should be clear, that if the motion for denial of bail fails, then the court should default back to whatever the code would have the court do in setting bail and release conditions. Expedited appeal process. The statute would require that, and again, as I mentioned, we believe it's important because, again, we are asking somebody to be held without bond until their case is resolved. Given the nature of the impact on the defendant or the public, the law would reflect that appeals would happen expeditiously, but not until both parties have had the opportunity to brief the issue. Further, while typical interlocutory appeals stay the proceedings, the statute would allow for proceedings to continue during that appellate litigation. So the case itself is not going to be on hold until the Court of Appeals has a chance to determine the bail determination. The court can continue to keep the case on track and march toward a resolution. It's also important to note that subsection L would allow a court to revisit their decision at a later hearing, especially if new evidence comes to light. Given the nature of the impact on the defendant or the impact on the public, the court may reconsider its order if new material information becomes available, and the court may then order a new hearing. And that's really not that much different than what happens now. I've gone through a number of cases where we've had more than one bond hearing in a particular case, especially if new evidence comes to light. Finally, we will look at an amendment to Indiana Code 3533-8 3.8. That particular code section covers the court's consideration of IRAS when determining bail. And that's the Indiana Risk Assessment Tool. This is just simply cleanup language in Section 3.8 that directs the court to consider the Indiana Pretrial Risk Assessment Tool, if available in these situations, but states that administering it is not necessary if it would delay the setting, modifying, or denial of bail. A few closing points. We were also asked for our input or comments on a statewide bail schedule and mandatory minimum bail for repeat or violent offenders. In terms of a statewide bail schedule, within IPAC and prosecutors across the state, there is a fear of the loss of local control and discretion over bail if this were to take place. I think, just speaking frankly, it would only gain support if it establishes a minimum bail amount that the courts would have to adopt, but would be free to set higher amounts if they so chose. Also, we don't think it would be necessary for misdemeanor offenses. So those are a few of the points that came up in discussing that issue. In terms of mandatory minimum bail for repeat or violent offenders, our thought was that the legislature and governor have taken steps toward that and addressed it in large part by the Indiana Code 3533-8 3.4 and 3533-8 6.5, where these types of offenders who have committed violent offenses now are being held without bail until they come before a judge and a prosecutor and a public defender or hired defense counsel to then decide in open court what the appropriate bail should be. So that's been, in our view, a significant step forward in trying to make sure that those offenders who do pose a risk to the community can have a bail set that will reflect the dangerousness that they pose. So those are the thoughts that we had on those 2 points.
We have 2 more presentations, but I hate when they make everybody go and then you get to ask questions at the end. So let's just do it individually. Not that we can't have a discussion after all 3 presentations are over, but are there specific questions for Prosecutor Holtzclaw? Representative Pierce.
Thank you, Mr. Chairman. So on the point of a potential minimum bail schedule, the prosecutors are fine with it being able to elevate it, but you wouldn't want a judge to have discretion to lower it?
No, I guess I wasn't clear on that, Representative Pierce. What we were sort of afraid of is that the statewide bail schedule would come out, that it would be mandatory that every court has to have the same bail schedule, but all of a sudden, the bail schedule that we've used for my 27 years in Greene County now has to be lower than what it currently is. Do you understand?
Okay.
That was the concern there.
So I may not fully understand how all that works, but what kind of pops in my head is, we have advisory sentences, right? And the judge can choose to go up, I guess, if they're aggravators, go down if they're mitigators, or I guess other factors. So I kind of envision maybe a bail schedule would work that way. Is there a way why that wouldn't make sense?
Well, let me tell you how I can speak toward Greene County. So we have a bond schedule that is set and posted. Now, setting aside those two statutes that just got passed that require people to stay in jail until they have their initial hearing, set those cases aside. For instance, if you're charged with a level 1 felony, your bond is set at $40,000 with 10% cash allowed. So you can post that before your initial hearing. When you get to the initial hearing, the judge will take evidence from both sides and could raise it, could lower it. If he or she doesn't raise or lower it, defense counsel can file a motion, and they often do, to reduce bond, and we have another hearing at a later date to again consider that. It just sets a bond schedule so that when you're arrested, that's how much you post, or you can post at arrest and be released prior to your initial hearing. So again, my concern would be our concern would be that if it was statewide and it was mandatory, it had to be this amount. What would happen if it was the finished product would be that the bail amount would be less than some counties already have. Would we then have to lower our bond schedules? And again, this just sets bail until the initial hearing. Again, oftentimes it's changed once we have the initial.
Mr. Glass?
Is the difference in bails, like, two different counties can charge different prices for bail? Is that
Yes.
based off of how much it costs to run through the courts? So like Marion County Court is more expensive, or why is there that difference in those bails from county to county?
Well, Justice Goff and Judge Spitzer could probably talk about this in greater detail, but it's my understanding is that each county, the courts get together and agree upon a bail schedule that is approved. I think maybe it's also approved by the Supreme Court at some point, and it's again local control, local discretion, and that's how it's set. And I'm sure we have 92 counties. There may be 80 different bail schedules. Maybe there's 92. I don't know, but it's a local decision.
Senator, if I might, Mr. Glass's question, we have a non-unified court system in Indiana, which in the most simple terms means that we don't have a common budget or a common administrative structure. And so as a result of that, there is great discretion among our trial courts as to local practices and procedures. And by and large, they can adopt practices. We might think they're a bad idea, but it's frankly usually inappropriate for us to even say it might be a bad idea, because if somebody challenges that on appeal, it's going to come up before us. The one thing that is slightly different in my practice than what Mr. Holtzclaw said, there's a lot of good about the presentation, is that we do not have approval of our bond schedules. So, I mean, they're going to come through. There is some review, but even among courts in a particular county, there may be a difference and that's somewhat mitigated because we'll oftentimes have in smaller counties in particular, certain crimes are charged in one court or another, but there is a great deal of variation. And, the problem with taking away the local control is it does sort of move someone's practice procedure. I don't want to say cheese, but it is important to understand that sometimes that number, it relates to a lot of different things, and we just don't have a centralized schedule, but for a number of reasons. We just don't have that administrative ability to say you shall have this number. So and I don't think that's self-evident. You know, when somebody comes in, you'd expect it otherwise. Some of the bonds are tied actually to fines and costs. Sometimes that money is used for it. But really the statute lists out the considerations that are to be used by a court when they set the bond. And so it's not simple. It's kind of a multi-factored consideration that goes in.
Judge Spitzer.
Yeah, so, and just to give an idea of some of the factors that may be in consideration in setting those individual bail schedules. So, different counties have different capacities in terms of their jail. And so, for example, in Grant County, where our jail is overcrowded, we actually are paying Tipton County and Fulton County to keep some of our people. We're looking at building another jail. And so part of setting your bond schedule is to make sure that really only the people that need to be in jail are in jail. And so you're setting it at a point where you hope you achieve that. And then we'll talk a little bit more about sort of evidence-based pretrial and how that helps achieve that end. Also, if you have cash bail rather than surety bail and you have a public defender system, the cash that's posted by people for bail can be used to either pay attorneys, private attorneys, or a public defender fee as well. Different counties have sort of different, the populations have different abilities to post bail. So bail in Hamilton County, in terms of what your typical person can afford, is going to be different than what your typical person in Fountain County can afford. And so there's a whole sort of host of factors that go into setting a bail schedule. Now, that's not to say that it is a science. It's more of an art or a guess, and we've modified our bail schedule over the 19 years that I've been on the bench several times. And I would still say it's not perfect, and I'll talk a little bit more about sort of the problems with sort of the whole cash bail system in general. But those individual counties will have individual considerations, and every county really is different with regards to that. So I think what Jared said is absolutely correct.
Sort of as an aside to that, in preparing for this, this month marks my 27th year as prosecutor in our office, and our bond schedule has not changed in those 27 years. So, I mean, I wish my wife's Walmart bill hadn't changed in the last 27 years. It has dramatically changed, but we have been we have been very consistent in those 27 years, with the only change coming when we went to the level system instead of the classes. We combined level 1s and level 2s and level 3s and level 4s with the amount, but it was the same amount that we used for class A's and B's, class C's and such. But we have been, we've not taken inflation into account when it's come to bond.
Mr. Glass, I would say, you know, I appreciate your, we're just going to live with some feedback. I appreciate your question, and I appreciate you being here, because I think I love the different perspectives. I mean, the judges are going to come with a perspective. You know, the public defenders are going to come with a perspective. The prosecutors have one. I have one. I mean, the sheriffs are going to have a perspective. The community corrections folks, the pretrial folks are going to have a perspective. And oftentimes, I think we're not looking at it from your perspective, which, you know, look, in my days on the city council, I would say, you know, I was pretty famous for saying, guys, somebody's paying for the criminal justice system. That's a fact. So then let's work our way backwards from that and say, okay, who pays for it? And every day of the week and twice on Sunday, someone that has the ability to pay, that commits a criminal offense, should pay for it before the tax-paying citizen pays for it. Now, that's a lofty goal and a lofty statement that I'm sure has 6,000 problems with it in practicality, but so I would like to think that maybe this group of minds can think of what's the goal, like what are we trying to accomplish, and if that is safety of our community and ensuring that people that commit crimes are not going to do it again. And look, I'm all for second chances, and you probably get me to a third chance, but there seems to be at some point we create what I call a pattern, And the pattern is what I really worry about. I don't worry about necessarily the one-off. I worry about, and Jared may have a, I mean, from his perspective as the elected prosecutor, he may say, well, I'm really worried about this. I worry about the 6 pages of criminal history that it just seems like we haven't gotten through to that person, and we need to figure that one out, as opposed to, because it's a lot of the same folks doing the same thing. So I appreciate your perspective, and one we as lawyers may not think about all the time. So, yes, sir.
Quick question. I don't know if you can find it quickly on your PowerPoint or not, but the language about whether or not evidence presented during a hearing could be used for anything other than impeachment.
Correct.
Does that apply to the accused has the right to speak, to testify at that hearing as well, right?
He or she would have the right to, but we couldn't compel them to. As the state, we couldn't compel them to. And any evidence that would come out at that hearing could not be then used later at the trial, except for impeachment purposes, or if at trial the testimony was wholly different than the bail testimony, then it may lay the groundwork for a perjury charge. But other than that, it would never be used against them.
So if the accused chose to testify and said, yes, I did it, you couldn't use that evidence later at a subsequent trial against the accused?
Not under the statute. I understand what you're asking. I doubt that would ever happen. But if it did, the statute would not allow us to do that.
I could see there being information that would come out less than I did it, but I was in another county when this happened, and that seems like an odd. I understand the purpose of it is to get to the intermediate question of, is this person a danger to the community? But it does seem like a strange thing that the accused could get up and speak and have been Mirandized and then be in open court say things that couldn't be used against the accused.
Well, they wouldn't be Mirandized at that point. And also, I anticipate that they will have some attorney, whether it's one that they've hired or a court-appointed attorney there before we have this hearing. And I would hope that they would counsel them about what to say and what not to say, in open court.
Oh, if Aaron Freeman was their lawyer, I'd be kicking their shin. Don't worry. Judge Spitzer.
Yeah, so the genesis of not admitting certain things into evidence that happened started with the evidence-based pretrial system when we're administering the IRAS. And there are some questions about drug use in there that help inform the risk assessment and sort of go into the calculation of whether or not someone is low to high risk. And so the idea was that just by asking them those questions, it wasn't fair then that we could then turn and give that money or that information over to the prosecutor and say, well, we learned this guy uses drugs, so go ahead and charge him with something else. And so that was the genesis of the idea of being careful in this process, not when we're asking questions of the accused, that we're not then creating a new criminal case for them, when in actuality we'd like them to be candid with us about their situation so that we can make an informed decision about whether or not it's safe to release them and under what conditions we should release them.
Yeah, that's a good explanation, Mark.
Anything else from Mr. Holtzclaw? Sir. Will you, Zach, help him with
I'm
his
sorry.
there?
And maybe this is, maybe I've not fully comprehended what's being said, but when you mention the minimum bail, in Hendricks County, we have had for several years a process by which we pre-screen anyone who is arrested. It's a joint effort with all of our judges, the sheriff, the prosecutor, probation department, the county council, because we fund the personnel, and we have a matrix that we use to pre-screen these folks who come in, and those who are not a risk to the community. And by this screening process, we can assure will appear for their next hearings, are released with no bail. They're released in their own recognizance pending the next hearing. When I hear this about a minimum bail, I'm wondering if that precludes what we've done, because we've saved a lot of money by keeping people out of our jail.
Right, I understand what you're saying, Larry. Couple points. You're from Hendricks County, right?
Yes.
All right, so I'm from Greene County. Our resource pool is remarkably different. We do not have the funding or the ability to do a lot of the pre-screen. I think bigger counties do. So to that point, not every county is like Hendricks County. Second, if you recall, I believe I mentioned that we don't feel there's a need for a minimum bail schedule for misdemeanors. And you might even get some of us to admit that there's some level 6s that wouldn't need a minimum bail schedule. I mean, HTV comes to mind as an offense that rarely is that person a risk to themselves or the community. We were asked to provide thoughts on bail schedule, so I provided our collective thoughts, and that is that if it's going to happen, there needs to be some flexibility left so that communities that do have higher bond schedules don't have to lower those, and that there's no set amount for misdemeanors, which again make up the bulk of your non-serious, non-violent offenders. Although I would candidly say that I've dealt with a number of misdemeanors that are a risk to themselves or others. There are certainly domestic batteries as a misdemeanor. Some of those cases can be some of the most volatile defendants. But as a rule, misdemeanors are typically those that would require little to no bond or bail.
Good question, Larry. And look, I think anything's about balance, and there'd have to be something that balances what all the counties are currently doing and not just throw everything out and start over. I mean, that's not a good practice, I don't think, so.
And just to touch back on that, Larry, our bond schedule for misdemeanors, for a Class A misdemeanor, $100, and you can get out. For a B or C misdemeanor, if you're even arrested on that, it's $50.
That's not even the court costs. Right.
But
it's been 27 years. So.
Yeah, it hasn't changed in 27 years. And again, I don't want to go back and start all this argument over with. I understand there are some communities where there are people that linger in jail because they can't make bond. That has never been an issue in Greene County. So.
Thank you for the presentation. Don't go far because we'll need you here in a minute. So thank you
for having me.
Zach, I think you're up next. 2 weeks, 2 different presentations, and you're subjected to me. So I'm sorry for the hazard pay that you need to get from Bernice back there.
This is what I live for. No apology necessary. Thank you, Senator Freeman. So Chairman Freeman, members of the committee, good morning. Again, I'm Zach Stock. I'm here on behalf of the Indiana Public Defender Council, and we appreciate the opportunity to speak today. We're actually really delighted with Mr. Holsklaw's presentation. You will be too, because I think he's cut several minutes off of our presentation. Because I think what I want to focus on is it seems like prosecutors and defenders do agree on one thing, and that's if Indiana is going to authorize preventative detention, it has to be governed by strong, uniform procedures. So the question before this committee isn't whether there should be a process for preventative detention. I think that was the question last year. I think it's transformed into a question of what is that process going to look like? And particularly, how's it going to work in courtrooms? As Justice Goff pointed out, we don't have a unified court system. What's it going to look like in 92 different counties? So I think the people who convened us here are to be commended for the foresight. If we work on this now, I think we're going to avoid some headaches in the future. So obviously we're here because preventative detention, we're kind of almost assuming it's a foregone conclusion. And it did pass the first time around with a lot of bipartisan support. We have consistently opposed the amendment in the first place. We're concerned that preventative detention is going to undercut the presumption of innocence without appropriate due process protections. We're concerned that jails are going to be overtaxed if we do not implement a preventative detention regime alongside reform of the traditional cash bail system. But we understand that the amendment has a momentum, and if it comes, we want it to be the best system it can be. So to do that, we need a framework that's going to safeguard due process, limits detention to clear and proven necessity, and rebalances the cash bail system as we know it. I guess I should have been moving my slides. So, yeah. Why is due process non-negotiable? I think it's worth stopping for a minute to talk about why I think we've come to some agreement. You could say, well, the 14th Amendment says so. That's why. We're guaranteed due process. And if we leave it at that kind of level, I don't think we fully grasp what we're trying to accomplish here. There's a deeper point. Due process is a constitutional check on arbitrary power. It forces the state to justify the restraint that it seeks with rules and not hunches and feelings and impulses. And due process, I think, is really important because it reduces error. Notice, a hearing, a real chance to respond with an attorney can bring forward facts that the state's missed, innocently missed. It can correct mistaken assumptions, and it narrows the disputes. Fewer mistakes means fewer unwarranted detentions and a safer, more accurate system. And this is a point that I don't think we make enough about due process in general. It enhances legitimacy and dignity. And when people are heard, even when they lose, they're more likely to accept the outcome and comply, which strengthens public safety and trust in the long run. So yes, due process is required by the 14th Amendment, but it's more than that. As the Supreme Court said in United States versus Salerno, which is why we even have the concept of preventative detention in the first place, in our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. We have got to remember that we're making assumptions about guilt prior to trial, and we have to maintain our focus on the guiding principle of our system is that you have a right to face your accusers in front of a jury of your peers. So this is a big deal, and we need to make sure it's really limited. The question is, how is it going to be limited? So I was going to go into more detail about Salerno and such, but the prosecutor's presentation has saved you from all of that. I just want to pause here to reiterate that Salerno didn't give us a blank check. It didn't say preventative detention is always and everywhere constitutional. Again, and I'm probably beating a dead horse at this point, the Supreme Court was confident that it wasn't facially invalid, that it could be constitutionally implied under the right circumstances because the Bail Reform Act of 1984 has a list of robust due process protections. So I don't want to belabor the point. I probably am beating a dead horse. But if Indiana authorized preventative detention without establishing procedural safeguards, we're going to risk arbitrary and inconsistent detention practices across the state. If the legislature doesn't act, the courts are going to fill the void. And this means litigation, this means delays, this means inconsistent rules across counties, and it's better to do it now. So what are these due process protections? Mr. Holzclaw went through a list with you. I think we agree in broad brush, devil's in the details, but in broad brush. So what do we need? We need a prompt adversarial hearing. We need the right to counsel, including appointed counsel for those who can't afford it, the opportunity to testify, present witnesses, cross-examine the state's witnesses, a burden on the state to prove by clear and convincing evidence that no conditions of release will reasonably assure safety, findings of fact just from the judge justifying detention, strict adherence to speedy trial procedures throughout, so detention's not indefinite, and a right to appeal or seek review of the detention order. Mr. Holzclaw gave you a bunch of lists that do a lot of those things. We have some concerns with some of those lists, and I hope the committee between now and the final report, maybe informally or in various sidebar discussions, can talk about them. Chief among our concerns is the suggestion that there would be limitations on the ability to cross-examine victims. I think we're really worried about if we're denied that opportunity, we're sort of denied the whole enchilada, so to speak. At a minimum, there would have to be something like a protected persons process like we use with child victims. We're concerned about the factor list of dangerousness. You know, once you hammer into place or carve into stone a bunch of factors, I think we start to move away from the evidence-based determinations that we've been talking about that some of the pretrial counties have been able to set up, and that I think Judge Spitzer will probably talk about. We've got concerns about interfering with the court's ability, the Supreme Court's ability to set the appellate rules appropriately. We don't know that we need to do that in statute, and other things that we can talk about. I just want to point out, we have broad agreement, but again, the devil is in the details. And we prefer maybe to start with something simpler, something like Senate Bill 410 from this past session, which was authored and introduced by Senator Pohl. It sort of it kind of accomplishes the same things as a lot of the language that the prosecutors have suggested, but it's starting at a much more basic level. So either way, whatever the starting point is, we're happy to continue to work with all of you to get this right. Now, before we go, we're concerned about the impact of preventative detention on jail populations. So, lest you think I'm being an alarmist about that, I want to read a quote from a report prepared by the University of Chicago Law School about the Bail Reform Act of 1984. So, in 1983, there was no such thing as preventive detention. In 1984, the Bail Reform Act is passed. Now we have a preventive detention scheme. In 1983, less than 24% of people charged with federal crimes were detained pending trial. The year after the act was enacted, the federal system's pretrial detention rate increased to 29%. 19% of arrestees held without bail, and an additional 10% held on financial conditions they could not meet. Pretrial detention rates proceeded to soar so that by 2019, people charged with federal crimes were detained at a rate of 75%. Now, our jails, Sheriff Mayer, our jails cannot hold 75% of all people charged with crime. So what should we do? Preventative detention is going to create this two-tiered system, basically. A detention scheme for unreasonable risk and a traditional pretrial regime for everybody else. Now, this could be an opportunity. And handled carefully, it could reduce reliance on money bail while protecting the presumption of innocence and promoting public safety. It could be used to detain the dangerous while allowing the low-level nonviolent offender to be released. How do we do that? Well, we really need to double down on our evidence-based decision-making, our pretrial programs that Hendricks County has that Judge Spencer is going to talk about. I know, as Mr. Holzclaw said, the counties are different. They all can't afford it. Well, we might have to think about helping them out that way instead of abandoning what has worked, what I think Judge Spencer is going to show you has worked. So I'm not going to belabor that because Judge Spencer is going to do it better than I ever could. But we just want to say this about cash bail. Cash doesn't equal risk. It never has. It's a proxy for wealth, not safety. So $50 for a misdemeanor is low. But in a country in which, in a state in which, a significant percentage of our fellow Hoosiers do not have $400 to meet the emergency needs of their family, they don't have $50 to get out of jail. And if they're in jail on a $50 bond, that's pretty much an admission that that person is not a risk. If they were a risk, it'd be much more than $50. So using dollars to sort people tells us who can pay, not who we should be worried about. And then finally, I think we think that if you continue to develop and utilize our evidence-based tools and we're going to have this preventive detention regime, we could create a progressive options. We kind of already do have these things. If there's no risk, people should be released on their own recognizance. If that's what the assessment tool says, that's what should happen. If there's some risk, well, oppose conditions accordingly. Maybe that's bail, but maybe it's electronic monitoring. Maybe it's a reporting schedule. Maybe that's a lot of other things we haven't even thought about. And if there is an unreasonable risk, you reserve preventive detention for that slice of people. So this progression, though, is only going to be as good as the process that protects it. Timely hearings, meaningful proof, and decisions grounded in evidence rather than cash. If we don't hold the line on that, I think the history of the federal system says we're going to overuse jail and we're going to undercut the presumption of innocence, and we're going to be here in a couple of interims from now, different people, maybe, saying in some future interim committee, why are our jails so full and what are we going to do about it? So with that, I'm happy to take any questions.
I'm going to take the liberty of asking the first one. Walk me through, as I said at the beginning, I don't make assumptions and I don't go down that road often. But let's assume that the legislature passes this again this year. Let's assume it goes to the ballot in 26, and let's assume it passes. When would it be best for the legislature to act? Meaning in the spring of 26 or the spring of 27?
We think this coming session, so spring of 26, so that.
And do you delay implementation? Like instead of making it a July 1, 26 implement, you make it a July 1 or January 1, 27?
I think so, right. Whatever coincides with the effective date of the constitutional amendment, which I think would be, well, I think there's actually debate about that, but if it passes on election day, November 2026, I think it would at a minimum be effective January 1st, 2027.
All right. Any questions? Senator Pohl, good to see you. I only gave you a slight hard time at the beginning just because you were not here to defend yourself.
That's all right. That's all right. Appreciate it. So thank you very much for your presentation, Zach. One of the due process protections that you had was the right to an appeal, and the way that you had stated it was the right to appeal or review. Could you explain kind of, what you would anticipate if it's not like an interlocutory appeal, reviewing the determination, what would it look like on review?
Well, that was probably a mistake because, as all the non-lawyers know, we can't stop at one word. It's always got to be appeal and review, or
I was wondering about that.
But we mean appeal. It
Okay.
should be an interlocutory appeal.
Okay.
Yeah.
Any Prosecutor Holtzclaw?
I forgot. Sorry, I reviewed your presentation beforehand, and I really liked one of your slides. I wish I had it in mind, because I think ultimately this is assuming passage, this is what's going to happen. I disagree that 70% of our defendants are going to be preventively detained. I think it's going to be not to borrow from the Supreme Court's worst of the worst language, but I think it's going to be the most serious offenders that we see, that we file for that request. I also don't believe that all other offenders should be released without bail. So the slide where you had, yes, no risk, no bail, some risk, and an unreasonable, that's kind of how I see this playing out. Now, we all may have different views about how big those sections are, but would you agree that those that go in the some risk, those offenders that do pose perhaps some danger to themselves or others, but not to the point where they need to be preventively detained, that there should be some form of cash bail for them?
So I can't take any hard and fast positions. I think the point of our entire presentation, though, is that if we move towards an evidence-based preventative detention system, if we're making decisions based on scientifically valid, objective data, evidence that's presented in front of a judge, and that judge has a picture of that person's dangerousness, risk of flight, we have tools at our disposal other than cash to get those people that will respond to the risks that those judges find. I think that's the point we're trying to make, that in a world where there is no preventative detention, I mean, this is as I said in the outset, we've been opposed to it from the beginning because a lot of it because we're afraid none of the things we're talking about are actually going to happen. You say, and I'm an optimist, I tend to agree with you, that 70% of people won't be held. I bet that's what Congress thought in 1983. I'm almost certain that's what Congress thought in 1983. That's what the federal judiciary thought. And I think the law of inertia, the bureaucratic impulse, the incarceral impulse that we have, it's going to take over.
But to be fair, the feds don't prosecute HTV or shoplifting from Walmart. I mean, there are a whole host of things that we deal with on a regular basis that we would never ask for preventative detention. So I don't think we're going to get to 70%, but I can tell you that if our alternatives as prosecutors are either you seek preventative detention or this person's going to walk out with no cash bail, that is going to drive far more requests for preventative detention.
And I think where the detail that the devil is in here is and I think Judge Spitzer's probably going to be able to talk about this better than I could. What are the options? So when we say conditions accordingly, what's accordingly? What are the conditions? And there's got to, it's not, I think that's a false choice between no bail and preventive detention. I mean, yeah.
Your Honor.
I guess my question to Jared would be, realistically, what are your expectations that cash bail is going to accomplish for you if you feel like someone shouldn't be released? If grandma comes and posts, which is this is what's happening really, is grandma posts $3,000 and then the person gets out, how is that impacting public safety in any way that's better than if somebody makes a determination that this person is likely safe to release, and to release them? Why should you say, okay, we've made that determination, but also we want grandma to post the $3,000 too?
Jared, can I answer it?
Yes.
One, whose microphones are on, turn them off if you would.
Oh, I'm sorry. Yeah.
I'm new to the Senate Appropriations Committee. I could be the only one in the room, and I'm okay if I am. As Senator Pohl will tell you, I have no issues, A, saying what I believe, and B, standing in the middle of the arena saying, I could be the only one here and I'm not moving. Someone's paying for the criminal justice system. Someone's paying for judges, someone's paying for staff, someone's paying for courthouses, someone's paying for pensions, somebody's paying for it. So put me in the camp of there is an additional consideration in my mind for cash bail unrelated to the crime the person committed and their danger to the community. Someone's paying for the criminal justice system. Somebody's got to pay for all of it. And when given the choice between, and I see this no different than someone who has the means to pay for, like when you fine them, or someone that's indigent. I agree, and Zach, I mean, we disagree on some things. Everyone who's indigent should get a public defender. I have no issue, absolutely bedrock in my viewpoint of that. I conversely, though, am very bedrocked in those that can pay for a lawyer, should pay for their lawyer. And come with me to some courts. I can take you there this morning and show you an absolute failure in trying to determine who is actually indigent and who is not. And there's nobody behind the curtain checking. And the number of times that I left the courthouse as a young deputy prosecutor when the guy just said, yeah, I have no job, have no car, have no money, have no grandma, have nothing, and they get in their Ford Mustang and drive off, I can't tell you how many times that happened in my own personal experience. Nobody checks. And so I could, again, be the only one in the room, but put me firmly in the camp of there are other considerations for cash bail in addition to ensuring I'll leave it here. Bill Polian famously said, I love people that have skin in the game. So, Your Honor, I'll give you the floor to.
So I think that one of the things we need to remember about cash bail is that it's imposed prior to someone being determined to actually have been a criminal, right? They've been arrested, but they have not been determined to have been a criminal. We have a mechanism for having people who can pay, do pay for the criminal justice system. And that means after conviction, I'm required after conviction to impose fines, fees, and costs on a whole host, depending on the type of crime, for a whole host of things. And it's a big number. It's often a big number. And so those people that are convicted and pay their fines, fees, and costs are in fact paying for the criminal justice system. The only other thing I will say, and I've said this multiple times in the past, is that the judicial system is the only branch of government that has to pay for itself. No other branch of government is expected to pay for itself. But leaving that aside, we have a mechanism for that. After someone has been determined to be a criminal, they've committed the crime, either they've admitted or a jury of their peers has said that they are a criminal. At that point, then, we impose fines, fees, and costs. They pay those fines, fees, and costs. They got skin in the game.
Yeah, and I would, look, I'm not, and let's make this point before we move on. I think our current, I've said this for many years, it's why I love, and I mean that sincerely, I love Rodney Pohl. Like, no better colleague, despite party, than Senator Pohl. Senator Pohl and I disagree on a variety of issues. I think you would be surprised, and maybe to Rodney's, I shouldn't probably say for his political future, there's many things we agree on. I mean, the state of our dialogue in this country has got to get better. And I hope that without anything about recent events, I pray to God our country gets to a place that this room becomes the norm. Your Honor, you and I can disagree about cash bail. You are a fine human. You are I will defend your right to be wrong every day of the week and twice on Sunday, right? As I hope you defend mine. And we should shake hands, and I should buy lunch, and we can agree on the 99% of the things that we agree on. And that is why I love Rodney Pohl, because he is exactly that. He and I can disagree vehemently on the Senate floor, and he and I will go to lunch and not be disagreeable about it. Now, look, he's given me the Freeman, you're absolutely wrong. And I'll tell him, yeah, you're probably right. I mean, who knows? But I hope that I hope this room and this commission can be and I hope our legislature, frankly, is where good governance happens, where good discussions happen, and we can set an example for what, frankly, is not right in our society, both on social media and in our just normal dialogue. I mean, people need to be respectful. I can disagree with the court, and Your Honor, I respectfully disagree, and I file a motion to reconsider. I mean, there is a process how this should work. And I appreciate all of your commitment to doing that. So let's start there, and then maybe I'll let you all present, and then we can talk further about cash bail. Prosecutor Holtzclaw.
If I could, just to answer Judge Spitzer's question about grandma posting $3,000, that doesn't happen a lot in Greene County, but I would say this. When grandma does that and she has $3,000 out of her retirement account, I think she's going to be far more inclined to make sure that her grandson shows up for the hearing. Same way as when the defendant is charged and he has, to your point, skin in the game and has $4,000 or $10,000, far more likely for him or her to return back to court. So I think that is a purpose of cash bail. And when they do post it, they are posting it before they're found guilty. But if they are acquitted or if the case is dismissed, that money is returned to them. So I just want to make those points, Senator.
Your Honor.
You know, I don't agree with much of anything that's been said in that interchange, but one of the things that I think is helpful when you're trying to figure out how to significantly change or build a system like this is to really just understand what the current condition is, what the change is going to be. And from my perspective, it is going to be an important change that I generally view as good, notwithstanding the possibility of abuse, to have the ability to preventively detain somebody who's dangerous. I had a largely misdemeanor docket for 12 years, which meant all the domestic violence cases in the county. And so one of the things that was difficult was holding somebody that was truly a danger. You were confident they were. The proof was there. And you almost had to be dishonest about it because of the impediment that is included in the current constitutional language. But this disagreement about what those three steps look, I mean, you have Zach up there saying it's a generally good idea, you have Jared saying this is a generally good idea. The disagreement comes in the middle, and that's less a philosophical disagreement than it is a local resources disagreement. Now, there's some philosophical disagreement, but Larry's got more in Hendricks County, which is my current home county, than Wabash County does, my old home county. And so one of the things I think it's important for the group to understand is part of the good work that's happened over the past 10 years when y'all gave us criminal justice reform, the consequence of that for local governments was we've got all these low-level felons that are now local problems. And so it really took a lot of collaboration. I know some people don't like that word anymore, but I don't have a better synonym for it. But you had to have all of the stakeholders in the community get together and figure out what you're going to do with this population of people who can very well be dangerous in a local supervisory situation. Sometimes that meant getting them on electronic monitoring. Sometimes that meant connecting them to a local community mental health center. Sometimes it meant other things. I mean, you never know what's going to come in the door. You still go to the county courthouse every day, Aaron, right? But what we've done is we've provided a process where some of our employees will go out into a field in the county and they'll talk to all the local stakeholders and say, how are you doing things now? What would you like to see different? Here are some resources that we can put forward to make sure that these gaps in your system are filled. And in large part, you know, that's meant to solve a problem that was just being addressed a few years ago with jail overcrowding. And now the pendulum is swift, and we are really all concerned, rightly so, with violent criminals, but nobody's opposed to preventively detaining violent criminals. I think that the important conversation, though, is what do we do with this other population of folks that are going to be in the community if they do get in a situation where the jails are going to go back the other way and we're in an overcrowding situation. You will have a situation like a lot of our jails do, well, they'll be the subject of federal litigation, and then you will have less discretion, less ability to have choice. And so that's why it is important in our non-unified system that we do have a process like we have in place right now with where we can go out into the field and certify pretrial practices and say, this is a good, acceptable way to do it. It's not perfect, it's not, but it is reflective of your local resources. And so, I mean, I would just urge you all to sort of keep that in mind as you're going through here. If this happens, I think it is generally a good idea. I don't think anybody disagrees with it. We want the dangerous folks to remain where they belong, right? So that the community is safe, but we've got this whole other population that end up in county courts, sometimes because we don't have other local resources to call upon, and we need to figure out what we do with them in a very different funded system. As Larry would probably tell you, it's like 70% of a county's budget goes to the criminal justice system. And so you have some of these counties going to be suffering through, property tax changes. They really need to have some support to make sure that this population of folks in the middle have some adequate, I tend to agree with you that, that's back to my point, is if we could just be honest and say if you have the ability to pay, maybe this bond should be, I always had 10% cash deposits on personal appearance bonds because that gave me some more discretion about where to apply that money than if it was just straight cash. And so those are complicated. I'm sorry to go on, but it does really require not only a more comprehensive discussion, but about 91 other discussions about what that looks like. And I really do want to give kudos to Chris Bean, who's really responsible for our certification, because that is a way that we've found pretty effective to go out into the field into these local systems and bring some uniformity, but also be sensitive to the fact that we have very different resource levels in our county-based system. So I appreciate your time, sir.
Mr. Gladys, direct.
Not director. Not yet. Mr. Stock, you mentioned that you wanted to expand IRS and IS. You mentioned that it makes me, when you mention something like that, it makes me think that you're looking for the state to come up with kind of that difference. And as we all know, revenues are not as great as we'd all like them to be, and hard decisions had to be made in the last budget. So my question is, do you have any idea what this expansion would theoretically cost, or what you're looking for?
I'm just a simple government lawyer. I'm not a numbers guy. But Justice Goff and I think Judge Spitzer, I think the court probably has some idea. And I think what I can speak to about this is, everybody understands resources are tight. Every question in this building is a question about what do we value. And what do we value liberty? Do we value due process? Do we value safety? We got to pay for it. That's the way it works. And to Senator Freeman's point, I do want to say, this came up a couple of times in the back and forth, we don't want to be overappointed, if that helps with the cost. The public defenders don't want to be overappointed. Frankly, though, we're flattered that people want us. Most of the time, people are rejecting us because they don't think we're real lawyers. So, we don't want to be overappointed. So I think it's just about finding, in all seriousness, it's about finding the efficiencies in this system and doing the right thing.
Sheriff.
Real quick about your question and overcrowding of jails. I've been blessed that I'm not overcrowded. This morning I was at 67 inmates and I can hold 225. Large part of that is that middle ground of some risk with pretrial, with electronic monitoring stuff. Those people would have been sitting in my jail, but now they're not. And they have to pay for that themselves. So it's kind of paying. So when your cost of what that costs, is it worth the state to invest in pretrial? And I don't know. I guess I'm ignorant. I thought most counties have a pretrial release service. We're new to it, but it's been a great assistance to my staff and the court system in general, in my opinion, in Adams County. And if that can go everywhere, I think you will see the cost offset of, the state might be paying for some pretrial services, but they're not paying for housing inmates, which is always more expensive, more risk, liability, and everything else. So of where that money comes from or what offsets, I think it can offset and maybe even be cheaper. I don't know that, but it's been a huge benefit in Adams County. Thank you.
Sir.
Yes, we can talk about the purpose of bail, and there's a lot of history. And no offense intended, but with respect to payment for the justice system, it sounds more like a user fee. And I don't think it certainly was not the intent of bail to begin with, and I would hate to see bail used as a user fee now. I think it gets away from the purpose, and I don't think, I just don't think it's a fair appraisal of the use of bail.
I appreciate the disagreement.
And let me say this too. Being on the council, I'm somewhat familiar with the cost of our justice system at the local level. And Again, I would say that an investment in a system of pretrial release and an evaluation of the risk is probably a very good investment. We've kept our jail population down, and it also helps with our judges. We don't, with this the system that we have, we don't have as many no-shows, so we don't have warrants issued for the sheriff to go out and bring in people who didn't appear for their hearings. So there are lots of advantages to the system that we're using. And if you have somebody who's released, rather than sitting in jail, that person, I hope, is still going to be able to maintain employment, provide for his or her family, which is a savings of another sort.
Good point. Anybody else? Zach, thank you. Just make sure our mics are off. Judge, is Chris doing this with you, or is this? Yes, okay, all right. Thank you both for the time.
They're getting that pulled up. My name is Chris Bean. As I sort of introduced myself just a little bit ago, much shorter than the previous speakers. I am the director of the Justice Services Division at the Indiana Office of Court Services. Briefly, Justice Goff talked about and credited me with going out to the communities and helping certify and provide some level of oversight for the pretrial agencies around the state. And it's fortunate that we have a number of representatives on this commission that come from counties that have certified pretrial agencies. So the councilman from Hendricks County has a certified pretrial agency. The sheriff comes from Adams County. They have a certified pretrial agency. And so some of the things I'm going to show you this morning, it's fun to do anecdotal conversations about what's going on. I'm going to show you what's actually going on in the counties that have certified pretrial agencies. My hope was to be able to demo our live dashboard, pretrial dashboard. Unfortunately, without VPNs and going across branches of government, we're going to have to settle for just screenshots. I did bring some copies of the presentation. They're updated, so these are the most updated numbers that you're going to see around pretrial and what's happening with our certified pretrial agencies. Did you want to introduce yourself first? Or?
So why don't I talk a little bit about, I think if we're thinking about making a big change in the justice system, it's important to get back to first principles and kind of tell you how we got here. And so Chris is going to talk to you about where we are now. I want to talk a little bit about how we got here. We got here, some of you even who are in this room or their predecessors participated in something called statewide EBDM. IPAC was part of it, IPDC was part of it, DOC was part of it, Sheriff's Association was part of it. And it was a discussion about how to sort of improve the justice system in a number of different ways. And it was a collaborative discussion. And one of the things that we took on was the issue of pretrial. And those of us that were in the justice system found that the cash bail system as it existed at that time was an imperfect way to do business. And there are really three different reasons why it's imperfect. First of all, money determining whether someone is in or out of jail seemed to be sort of antithetical to what we were about as Americans and as Hoosiers. If you're familiar with, you ever been to Washington, D.C. and seen the Supreme Court building, you notice that right on the front it says equal justice under law, right? So what that means is that everybody is entitled to equal justice in our justice system. Article 1, Section 12 of our own Constitution talks about the fact that everybody has access to the courts equally. And so there's a sense where money bail is a little bit antithetical about that. How much money you have determines whether or not you stay in jail or you get out. So that's the first problem. The second problem is that people who you think get out might not get out. Let me, an example of this. If I set bail at $500 for a level 6 felony, for example, I'm anticipating that person is going to get out of jail. But what do we know? And I challenge any of you to go to any county in Indiana, particularly those that don't have evidence-based pretrial, and you're probably going to find someone who has a $500 bail posting and cannot get out of jail because they can't come up with $500. And I guarantee you that the judges and probably even the prosecutors thought that by setting that bail amount, they were going to get out, but they don't. So they stay in jail, and that's expensive. The third problem is that people who you think will stay in get out. So sometimes you set bail at $50,000 cash. And then grandma ends up and puts up her house or posts $50,000 cash. And this is a bad dude that you want to keep in jail pending because they've got a long history of doing bad stuff. And they're likely to do bad stuff if they're out, and you're really concerned about that. And so you set a high bond, and then they post it and they get out. So that's the problem with the money bail system. So we had a conversation about that. Preventative detention and discussions about that, that's one way to avoid that third bad thing happening, right? If you can say you're going to stay in jail and that's it, that's preventative detention, and that solves that third problem. But you've got the other two problems that I talked about as well. So what we came up with then was a system of evidence-based pretrial. And the way that we went about that was we looked at the best research that was out there in terms of, what have other jurisdictions across the country, how have they structured a system that would not be money bail based, that would be more based upon information about the person to help a judge make a decision. And so we had that conversation in the 20-teens. So in 2020, we adopted our pretrial rules in Indiana. That implemented this evidence-based system. And what it consists of is that you do a risk assessment for individuals that are in your jail, and then also you have a series of other information about that individual as well. So if I'm making that decision in Grant County, we have evidence-based pretrial. I've got the risk assessment system. I know where they work. I know where they live. I know what their history is in terms of failure to appear. A whole host of information that allows me to make an informed decision whether or not that person can be released or not. Doesn't have anything to do with how much money he's got in his pocket or how much money grandma has. And so that system has been implemented. I think we're about 32 people or 32 counties, and then we got another 15 or so. So about half of the counties in Indiana either have implemented this or are thinking about implementing this. Now, recent funding issues have impacted some of that, and some people have unfortunately had to back away from that because of funding issues. What Jared talked about in terms of counties being able to fund, that's a real problem. It really is. Since we started it in 2020, we've got some years under our belt to see how does it work. And so we've got data. And so, oftentimes when you're talking about bail, you have sort of one side telling you some bad stories and one side telling you some good stories, and you're trying to make decisions by anecdote. And we all know that the plural of anecdote is not data. You need real data in order to make good decisions, and that was built into this system. Is we're going to collect data, see how we do. If it's not working, we'll tweak it, or if it needs to be tweaked, we'll tweak it. And so Chris is going to talk to you about some of the data that we have so far as we're 5 years into this.
Thank you, Judge Spitzer. So a few months back, the Office of Judicial Administration sort of embarked on a project to come up with something in response to what the local JRACs have been asking for. I'm fortunate enough to be the one that creates the survey and then receives the responses annually from our local JRACs, asking them what they need, what would be beneficial. Without a doubt, every year, or without exception, every year, assistance in talking about data and displaying data about how their local criminal justice system is the #1 thing that they are requesting. So with that, we talked about some things that we do within IOCS around problem-solving courts and being able to better illustrate how our problem-solving courts are performing. But pretrial was beyond a shadow of a doubt the easiest one to do because we collect a lot of real-time data on certified pretrial agencies. So with that, we pared it down. These are not the only data points that we're collecting, but these are the two primary, and it's been talked about in the first two speakers, and that is the primary focus of pretrial is reappearance for court and public safety. So what we wanted to do was create a very easy, palatable way to demonstrate how local counties and the state are performing when it comes to those two measurements. And then I'll show you a third measurement that's newer, but really great. So this first one shows you a statewide pretrial measurement. I haven't narrowed this down. If once we roll this out, we will be able to say Adams County. If the sheriff wants to know how pretrial is doing in Adams County, he's going to be able to select Adams County, see his numbers compared against what the state is performing. Same thing in Hendricks County, same thing in Monroe County. So what we know today with our most recent information, and I should note this number of the total case count, if you know the criminal justice system, you know that the criminal justice system, even in the 32 certified pretrial agencies, have processed more than 17,000 cases. To make this data better, we have filtered out those cases that haven't finished yet because we didn't want to get credit for the individuals that were maybe placed on pretrial supervision yesterday, haven't recidivated, or they reappeared for everything they're supposed to. So that would sort of taint the numbers just a bit. So these are individuals that have been placed on pretrial supervision in certified pretrial counties and have gone through the entirety of their pretrial supervision. And so what we can see is that if you can't read that, the light blue number are those individuals that scored as a low risk on the IRAS-PAT. The IRAS-PAT is the pretrial assessment tool. It's a very short tool to gauge two things. Again, the likelihood for reappearance and the likelihood to recommit an offense during their time pending this matter. So we know that low-risk people are showing up for court at a 93% rate. This is including individuals also that maybe aren't receiving supervision. This is everybody that is in a certified pretrial county and received the IRAS-PAT. Moderates are showing back up for court at 86%, high-risk individuals at 75, almost 76%. On the public safety risk level, individuals that scored as low are not recommitting any offenses and did not violate their pretrial supervision. So this doesn't just consider new arrests. This would also just be you failed to show up for one of your pretrial appointments. Maybe you are ordered to take a chemical test. You didn't show up and do those things. So they are completing without any kind of new malfeasance at about 92%. Moderate at 83%. Even the high-risk folks are doing well at about a 77% rate. Down here you can see the appearance rate by type. This one is, it's hard to show in a static display like this because the dashboard actually has a feature. If you hover over it, you get the denominator, so you know how many individuals were actually released on this type. So you could almost look at released on property bond and say that one seems really great. But there's only about 16 individuals that were released on property bond in those counties in the first 10 months of the year. Next, we break it down then by those individuals that are being supervised by the pretrial supervision agency and those individuals who are not. So we can see that in every category, individuals that are being supervised by a certified pretrial agency are outperforming those individuals who are not. And again, it's broken down by risk levels. So aside from release on property bond, I will say, again, there were 16 total cases out of the 17,000 plus. I think this number, is the most promising This number shows any new violent arrests during the pendency of a case. So these individuals, again, received IRAS PAT, were released on some level of supervision, and have or have not committed a new violent offense while they're awaiting trial. And so what we can see is low-risk individual or high-risk individuals, which all the way to the left there, are completing pretrial at almost a 99% rate without committing a new violent offense. The moderate risk, 99% also, or close to, and the low-risk individuals, almost 100%. So again, these things are based on the IRAS PAT. The IRAS PAT, and I just to kind of answer some of the other conversation that's happened in the previous speakers, the IRAS PAT, again, it's a very short form. It's a quick document. It really is only scoring on 7 to 8 things. It does not measure for dangerousness. So when we say they're a high risk, they're not a high risk for danger or violence necessarily. What that's saying is they're a high risk to not appear at court, or they're at a high risk to commit another offense during the pendency of the matter. So, current practice. Within these certified pretrial agencies, as Judge Spitzer talked about, January 1st, 2020, the artist formerly known as Criminal Rule 26 came into effect. The certifying of pretrial agencies also started. Grant County was our #1, our first certified pretrial agency, followed by Hamilton County, Monroe County, and we've started to add more and more. The release without money bond unless substantial risk of flight or danger, as measured again by those pretrial tools, those are not the only considerations that a judge or local attorneys are making or using when they're considering whether or not these individuals present a danger. So it's not purely, as the councilman talked about, a matrix. All of our certified pretrial agencies have an agreed upon matrix that is agreed upon by the local pretrial committee that includes local judges, prosecutors, defense attorneys, council members, or probation, almost everybody that may be working in the criminal justice system, law enforcement, and it says these are our local values. And what that means is we'll create a matrix with an X and Y axis that says here is their risk level, here's the nature of that offense, and you match it up on the matrix and you say this is what our local community values that individual at. This is what we think how we should respond to this individual in terms of whether they should be detained or whether they can be released on very low-level supervision. So when we talk about the evidence-based tools and we talk about IRAS and IAS, it should be noted for the discussion around pretrial, we're only talking about the IRAS pretrial assessment tool. That's the only tool in the IRAS suite of tools that is validated for this population and for these purposes.
Okay, so we kind of have already talked a little bit about this sort of the statutory basis for bail and bail procedure. One of the things we were asked to speak on is mandatory minimum bail for repeat violent offenders. We've kind of gone down that road a little bit in the last legislative session. You know, I don't know how much further we want to go down the road. A concern that we have from the Judges Association is that impacts judicial discretion. And when we use the current practice that we have, particularly in evidence-based pretrial, we can look at each case individually and make a decision based on that case. I think one of the things that the General Assembly should consider as they think about sort of the statewide, doing things statewide, is that has an impact on local resources. And so the more people are kept in that maybe didn't need to be kept in, that's an expense to local resources, and that's in essence an unfunded mandate. And so I think some care should be taken with regards to that as well. So that's really what I'll say about that. I think that Jared did a really nice job in terms of looking at sort of trailing language for preventative detention. Like Zach, I think we're kind of going to be on a similar page with regards to these, so there's not going to be a lot of disagreement, and certainly in the broad brush that we do need due process considerations when we have preventative detention. And so, you know, these are some of the things that I think that are important for us, or that we think that are important for us as we think about, you know, putting some parameters around preventative detention. We'd like to see bail defined as release and not money. We'd like that judicial discretion be preserved with regards to the setting of conditions if someone is released. We think it's important to have a presumption of release for most defendants. There should be clear standards of proof, and then there should be procedural safeguards, which should include prompt hearings with representation of counsel. And you may be familiar with a recent decision of the Court of Appeals talking about the right to counsel attaching at arrest. So we want to make sure that we're compliant with constitutional requirements. And then there are due process protections throughout the detention process. I think Jared and Zach both talked about those types of procedural safeguards that we would envision as well. Again, like Zach, I'll say that the devil's in the details, and there are some things we may have some disagreement on from a minor standpoint, but I think sort of what Jared had outlined in a broad brush is something that is a good jumping off point to consider. Got the same concerns as Jared does about the statewide bail schedule, and I think Zach outlined those as well. It impedes with sort of individual counties being able to evaluate and assess their own resources. It impedes judicial discretion. And in essence, and this is going to particularly impact rural counties, more people are going to be kept in jail, and then that's, again, an unfunded mandate. And so that matter is a concern. And, you know, then what we've seen from sort of the data that we've shared with you today, you know, supervision seems to be a bigger factor in terms of deciding who does well on bail rather than sort of the bond type either. And again, we would encourage the use of individual assessments, looking at risk factors, looking at those types of things that evidence-based pretrial provides. And I think the observations that were made by the sheriff and Mr. Hessen about how that is going to ultimately impact local budgets is you're going to have the people in jail that need to be in jail, but not a lot of people in jail that aren't in jail. And so you're not going to be paying for those people. Again, I think the observations that Mr. Hessen made, whenever we keep someone in jail that doesn't need to be there for a long period of time, what sort of the science tells us is that we're making them more likely to be criminogenic. We're taking away some stability factors that they might have, like their job. You know, maybe they're in school and they're missing out on that. Family issues. Maybe they can't make their rent payments, and so they lose housing. So it's important that we, you know, use precision rather than a big hammer with regards to those things, because we can impact public safety by making wrong decisions as well. So with that, happy to entertain any questions.
Chris, can I get you, if it's not, can you go to your third slide?
Yep.
So it's the Indiana pretrial outcome and performance measures. And then at the bottom, I'm looking at the bottom left-hand corner where it says appearance rate by release type.
Yes, sir.
So what is, if I am Hendricks County and I'm a certified pretrial program,
Yep.
what is the cost?
What is the cost to maintain that pretrial agency?
In essence, yes. Is there a big, like, an overall cost, or is it?
Okay, so it'll vary. And so I'll use Hendricks County. Hendricks County has embedded their pretrial agency within their probation department. So in that sort of format, which is the primary way that we've seen pretrial agencies roll out. It's nothing above what they were already sort of paying for on an annual basis. There are counties that have opened up a standalone pretrial agency, which is sort of the evidence-based best practice would be to have a standalone one with a sole mission. Its only mission is pretrial. Hamilton County was able to do that. We provide about $4 million every year to the 32 plus certified pretrial agencies to maintain. They were previously receiving some funding from DOC. However, with some of the reprioritization, about $1.2 million got cut from certified pretrial agencies. It's left us scrambling because we want to ensure that those counties that are doing this good work that's showing these numbers, they can continue. We have lost Marion County as a result of this, as their local budget was not going to look any better, they felt, in the next few years. And so they've sort of lost out. And if I can speak anecdotally, I spoke to a magistrate in Marion County recently, and he talked about the local prosecutors, local defense attorneys sort of expressing the loss of that pretrial agency, because it's, again, not just the IRAS PAT that a pretrial agency is collecting, they're also finding other things. If you look at Beachy versus State, it is a case where that bears out, and that is Beachy didn't do the IRAS PAT, but the court made a finding based on some other things that spelled out there was a risk of flight. And so they didn't do the correct stuff, and it was sent back to say, you need to do the IRAS PAT. However, on the other side, I will just motion towards Justice Goff on this, because DeWeese versus State is probably the one I think that has done the best at clarifying what this all is, what Criminal Rule 26 is, what certified pretrial agencies can do, and what judicial discretion still allows. And that is, the IRAS PAT was conducted. The judge also found some other things, like some other collateral information about that individual, and decided that they were too much of a risk. They didn't reduce bond. It came up through the appeals process, and ultimately it was found that that county had acted correctly because they conducted the IRAS PAT. And even if that individual scores as a low or a moderate risk, and your matrix may say release them, the judge said, yeah, but there's some other things. There is a danger to the community. So they were still allowed, with the judicial discretion, to make that finding that they weren't going to reduce bond. I apologize. I went on a long tangent there.
Believe me, Senator Poles used to, that is the shortest of tangents that I go on daily in the Senate. The question, I appreciate the answer. The question was intended to get to, look, the four columns there, cash bail seems to be the highest return to court rate that I look at. And then, look, I've been here long enough now that I anticipate my colleagues and the questions that the fiscal leaders are going to ask. Look, I disagree with Judge Spitzer that I can assure you there is a conversation that's going to happen, much to my chagrin, in the next years about tolling interstates. The executive branch has to find funds. The legislative branch has to find funds. I can assure you we are finding funds for Medicare, Medicaid every day we're trying, right? And it comes down to who gets benefits, who doesn't, who's paying for what services. And I view the courts as no different. Those that have money that commit a crime should pay for those services. Otherwise, I have termed it, you have cradle to grave criminal justice, because the taxpayer's paying for the police to investigate it, the crime lab to come do it, the pretrial services, the judicial services, the post services, the incarceration services, and those that should pay, that can pay for it, should pay for it. And again, I respect that we have a difference of opinion there. But I'm all for evidence-based pretrial services. I'm all for what works. it was interesting to me to see those that are supervised on a conditions-based versus tracking only. And inevitably, Ryan Mishler is going to ask me, Aaron, what does it cost versus if we do nothing?
Yeah.
And I have to be able to answer that question. So so it is relevant, I promise, for at least for my purpose of why, not to highlight a disagreement between the judge and I, it is because I know what I'm going to be asked in fiscal hearings, even if a committee that I chair in corrections thinks it's a great idea, I still have to go to the fiscal people, and that's a challenge. So I appreciate the help.
So one response, Senator, is that I think we would expect, as you look at sort of the science behind release, we'd expect people posting cash bail to sort of cherry pick people. In other words, the people who are posting cash bail kind of get cherry picked by people who have resources, right? So those tend to be people who would probably score higher on, well, lower, I should say, on the IRAS in terms of, so they're employed or they have family members that are available to them, things like that. So it's not surprising that you see people who post cash bail to show a little bit better on this, although it is interesting and significant to note that with supervision, then even things get better even with cash bail as well.
And if I may, just in terms of supervision, that is a sort of catch-all term, and it's locally dictated. So supervision may purely be that they're receiving notifications, text notifications showing up. It is some condition of that certified pretrial agency as agreed upon by the local pretrial committee.
Let's start on the right.
So yeah, I just wanted to walk through the mechanics of how this would actually work in an individual case. So there is a indictment against someone, and then what happens?
Okay, so I think if it's okay, we'll talk through a specific case. Chris Bean gets arrested in, let's say, Hamilton County. They will respond promptly. The pretrial agency will come over to the jail and they will conduct an assessment. In the jail, they will do the IRAS PAT, which while scores on 7 or 8 things, there's actually about 32 questions that they're asking. And then also observations. They take that information back to the office. They run a criminal history report. Then they create a document. If the individual is going to be not eligible for immediate release, I should say Hamilton County is somewhat unique that they have delegated this authority to their pretrial agency to make a release determination before the individual has to post bond or is seen by a judge. So they score a certain way, again, agreed upon locally. They can release them pending the initial hearing. So once the pretrial agency collects that information and they put together like whatever their local form might look like. I come from the juvenile delinquency world, which gives me a unique perspective on this because this is happening every day in youth justice around the state. You know, there is no such thing as bond. It's either you're detained or you're released, and then the judge makes a determination. But as part of that, we prepared what is called a preliminary inquiry. It is almost the same thing on the adult side, but it isn't a bench book document. It is whatever you've decided. What do your prosecutors want? What do the defense attorneys want? What does the judge want to know? They prepare a form and it says, here you go. This is this individual, everything that you want to know. They give it to the prosecutor, to the defense attorney, to the judge in a timely manner before that hearing so that Mr. Holtzclaw can go back to his office and say, I'm going to run a history check on this person. Maybe I can find out whether they have warrants in other counties and things like that so that by the time that they get to that initial hearing or meaningful first appearance, a detention hearing, whatever they want to call it, there is the opportunity to make have an adversarial hearing and allow the prosecutor to advocate for his side, have defense advocate for their side, and then the judge make the ultimate decision.
Zach?
Like I said, simple government lawyer, not a data scientist, but I wanted to drill down on building, I think, on Senator Freeman's question on this slide. I want to make sure I'm understanding it correctly, and if I have the question, hopefully somebody else in the committee has the question too. So in the bottom two boxes, if we stick to the charts on the far right, we've got released on own recognizance and released on cash bail in both those boxes, right? We can kind of throw out release on property bond in some way because it's almost a statistical anomaly. They almost don't exist, correct? And released on surety bond is complicated because the surety companies can get involved in terms of how much does this surety bondsman, do they send Dog the Bounty Hunter after people or don't they? Or, you know, yeah, no, I know they don't. Yeah, I'm sorry to even mention it. Yeah, I know they don't. Yeah, they don't. But so just sticking on those two boxes on the far right, would it be a fair interpretation to say that the dark blue, released on cash bail under release type, we have an 89.7% appearance rate. That's with tracking only, meaning electronic monitoring, meaning sending text messages to check in.
Also remaining in jail.
That could be remaining in
That
jail?
could be remaining in jail. This is everybody that wasn't released on conditions with that pretrial agency. So I'm glad you asked that question. It's a great question. That individuals who have remained in jail are also being considered in those tracking only cases.
Okay. So the difference between, and then supervised condition means I'm checking in with a probation officer, I'm on an electronic monitor, I'm being...
Not necessarily.
No.
It can be, it's locally dictated. Again, it may just be I'm receiving text notifications. It's just you were placed on sort of under the supervision of this pretrial agency. Please.
Get a little bit of the weeds on that, Zach. It tends to be, so pretrial is not probation, so it tends to be more of a light touch. And then if we look at sort of the research on what works best on that, a light touch does work best. So what you're generally talking about is you're talking about sending notifications, sometimes checking in with them by phone or in person. And then also what we're piloting and seeing some good results on are a warm handoff to things like mental health, substance treatment, and things like that.
And I think what I'm building up to is if we look at the supervised condition released on own recognizance versus supervised condition released on cash bail, we see a percentage difference of what, 2.1%? I mean, again, I'm not a data scientist, but like, is that a meaningful difference? And even if it is a meaningful difference and not an anomaly, can we attribute that to cash? I mean, aren't we just assuming that this tiny difference between the two has anything to do with cash?
My explanation is that, again, that subset of people that are released on cash bail are people that would, on the aggregate, probably screen out lower risk than the people that are released, than go through the pretrial system. And so, as a result, we would expect them probably their numbers to be a little bit better because they're lower risk. So that's, again, I'm not a scientist or whatever, I'm just,
But to put a finer point on it, you're saying it's not because they have cash or they put cash up. It's because they're the kind of people who qualify to put cash up.
Personal characteristics.
It doesn't have anything to do with the ability, and yeah, that's the point I want to make.
Yeah.
Right.
Jared.
To follow on your point, Zach, though, wouldn't it be two different types of offenders that would be released without any type of cash bail versus those that are required to have cash bail under this pretrial release system?
Not necessarily. Again, and I apologize. I'm not begging out of the conversation by saying it's dictated by local policy. There are individuals. So we talked about like the posted bond. So you have a bond schedule that's in your jail. You referenced it. There are those individuals that before they're ever scored on an IRS PAT, we maybe don't even know what their risk level is, come up with the $50,000 cash bond because they're assigned to a certain court and now they're out. So not necessarily. Some of these individuals, even the low risk ones, will fork over whatever that money is, get themselves out before they can ever be screened or ever interviewed by a pretrial agency.
If I may, Senator, I have a couple follow-up questions. So that was, again, not having a pretrial release program in our county. That was something that was, in your presentation, was a little confusing to me.
If I may, though, your county was pursuing it. As we've talked about, and you talked about a little bit, the fiscal side of this just didn't add up.
Yeah, there were also some concerns, too, behind the scenes about decisions being made without maybe the judge being the one to decide that. So, but my question was, it almost sounded like these people were being held and all this information gathered at the initial hearing, but that's not necessarily true, though, right? They could post bond before we get to the initial hearing, so therefore the IRAS, PAT score, and all the other stuff wouldn't matter. Is that how most of them are doing it?
If you're posting bond, IRAS PAT is not a consideration of whether or not you qualify for bond.
And the IRAS PAT is mostly made up of the defendant's own answers, correct?
That's correct. Yeah, and that's why there's, again, when we get to DeWeese, there are those collateral bits of information that should also be included in that consideration.
I think speaking for most prosecutors, the biggest concern we have about this type of system would be people, meaning not judges, determining that somebody can be released before an initial hearing and before the prosecutor has a chance to make their argument to the court about, hey, this is what also we know, not just what the defendant has told you on the IRAS, but also here's some information that we feel is important to determine whether this person is a risk to flee or a danger to the community. So again, I apologize. I'm just asking because we don't have that type of program.
I think it's a great question, Jared, and I'll just tell you from Grant County's experience that is called delegated release authority, and in Grant County, as in most counties, it applies to low risk, low level nonviolent offenses, and so it's not a lot of them, and that's a decision that's made by your local. That's a local decision that's made. We didn't start out doing it, and then we later said, okay, we've seen this work a little bit. We're willing to grant this delegated release authority, and it's not a big number of cases that we have in Grant County, but it's low level, low risk, nonviolent is what we've done, and I think that's the case with most counties. You don't have to have that as part of the system.
Is that, if I may ask, just based on the type of offense, or is it based on the IRAS score, or a combination of all of that?
Both, yeah.
Because one thing that you may not have at the time, because sheriff will confirm, somebody may get arrested, but Prosecutor Holtzclaw may not get that paperwork until 40 hours afterwards, and we're running up on that 48-hour limit. So you may not, and I may not have the actual full picture of what happened on that particular arrest. And it may be that sometimes officers arrest people and they don't realize, oh, I also could have charged this, or we find other information, like you said, that they maybe, from another county or another state, which may change our charging decision as well. So I was just kind of curious about how that worked, because again, the real fear is non-judges letting people out in the community without prosecutors giving an opportunity to make their pitch as to what we think should be appropriate in that particular case. So,
I completely
thank you.
agree. That's something that should be delineated and approached with care. You can think about things like violation of the school attendance law or non-support. Those are the type of things that
Driving while suspended.
felonies. Yes, yeah,
And I will say, in many of our counties, first off, that it's the exception is the delegated release. It is not the rule. Law enforcement in almost every county has that authority already by doing cite and release, or making some sort of what you just talked about, driving while suspended. This is going to be your court date. Here you go. So there are non-judges making those decisions every day.
Representative Pierce.
Thank you, Mr. Chairman. I wanted to ask you about this slide that's entitled No New Violent Crime Rate. And so I'm going to make sure I understand what I'm looking at there. So the overall population that's being portrayed here are people who've gone through the assessment, the risk assessment.
That's correct.
And how many counties right now do we have doing the risk assessment?
This is 92 counties are doing risk assessments.
Okay.
The only numbers that are included in this are the counties that are going through the certification process. So the certified counties, 32 counties.
Okay, so 32 are certified. So, and we don't know if the non-certified counties are doing as well as the certified counties?
We do, in terms of this no new violent, no,
Yeah,
we do
so
not know
we
that.
can't, maybe we can't extrapolate.
correct.
Okay, because if I'm reading this correctly, in these 32 counties that are certified to use this risk assessment system, for the high-risk people, I guess you could say the assessment is failing 1.39% of the time, right? Because we had a violent, and I guess there's two ways you can look at that. You could say, well, that doesn't seem like a really huge number, so maybe the system's good, so maybe we don't have to be wondering if we need to amend our constitution or make these changes. Or you could say, well, if my family member were murdered by someone in that 1.39%, that's a statistically significant item for me.
Yeah.
So I guess there's a couple ways you can look at that, but I think that's something worth kind of considering, that at least in places where we've been able, I guess, to get the resources to have a certified risk assessment system, it looks like it's working fairly well of keeping dangerous people, you know, from committing new crimes before they get a chance to be found guilty in their crime.
Yes.
One question that I have is, there's been some talk about setting mandatory minimum bail and the difference of where counties are, about how that might throw some wrenches into various local systems that have developed. If there were a system where there were categories where a minimum bail would be required, would that be an additional system? So, for example, a repeat violent offender. If there is a previous violent conviction and the offender comes back on a similar charge, if you have a mandatory minimum on that, would that be consistent with the entirety of the system that each one of the counties have?
I will say where it runs sort of contrary to what this system says is that it takes away the local discretion.
I guess that's the question is, are there certain instances where the local discretion should be restricted, such as you see, luckily, news stories from other states of people who are repeat offenders, and are there instances in those cases where a minimum, as opposed to the various counties where bail's set at a certain level, and this has been the system the entirety of the time for the last 50 years, would placing in a regime on top of that that says in certain circumstances, this is the bail for a repeat violent offender?
Let me say that there are challenges when we're looking at that type of regime or system and doing that. We need to be careful with it from the standpoint, if you're going to build that into a statewide bail schedule, somebody's got to figure out if somebody's a violent offender and tell a repeat violent offender. The only way I know that a guy in front of me is a repeat violent offender is if somebody tells me, right? So somebody's got to tell me. So that's why I like the evidence-based system, is I've got a sheet of paper that tells me if we got other charges pending, is he got a warrant from another county, is he on parole, you know, and that helps me make a better decision. So if we do that, we need to build in something into the system that says that you're gonna be able to tell us that, so that we can make those decisions. And that's harder than it seems, and I bet Jared's got some thoughts on that. So
my assumption would be that the prosecutor's office would bring that information forward.
So to go back to the two statutes that I referenced in my presentation that the General Assembly passed, Judge Martin, our Superior Court judge, elicited my help, and we put together a form that is at the jail. So anybody that is arrested, the officer that comes in has to fill out this form, and we have delineated every one of those charges that would apply or prior convictions. So they have to fill it out so that she has that information and Judge Allen have that information. It took a while to put that together because there are several variations between violent offender, repeat violent offender. and then the list of, 18 or so convictions that if it occurs against a family or household member, it applies, and we had to define for the officers what family or household member meant. But we did that, and we put that packet together, and so far that has worked. But to your point, Philip, about the bond schedule, again, to be clear, we have a bond schedule, but that is really, I shouldn't say only in place, but really only in place until the initial hearing. Because at the initial hearing, our courts routinely take information from both sides and they may review it. Sometimes we have asked in advance, hey, can we elevate this bond? And we make argument for that. So I don't want anybody to think that just because, again, it's a level one, $40,000 with 10%, it's always that. Sometimes it goes way down at the initial hearing, sometimes it may go up. And then there was one other point. Oh, back to this slide right here. I had a question for you. How do you define on this chart violent offenses, and does the blue tower at 98.61, does that include people who weren't able to make bond and stayed in jail?
To that one, this would include everybody.
Okay.
This is the entire pretrial population. In terms of honestly, I don't have the answer to that. I don't do the data in the background in terms of.
I asked because when we were last year, I had some people ask me about how we should define violent offender and repeat violent offender, and I came up with a list, and ultimately the legislature came up with a different list. But the point is, there are several different ways to define violent offender, and I was just curious about what you all use for that. Like crime of violence? Okay.
Welcome to the legislative process of negotiation. And Philip, your question, we could have this is where a person should remain silent, and I won't. We could have a multi-year, multi-session discussion about one particular county in Indiana, and you happen to be sitting in it, which, by the way, is where I live, predominantly where I serve, and predominantly, I go to court all over, but I'm here a lot. And to suggest that Marion County has challenges is being polite to the word challenge. And part of the bill that we did last year is just, look, the judiciary does a really great job, and they generally make really good decisions that I can support. An issue that a lot of us had is decisions were being made. I had never heard the term until Judge Spitzer just used it. Designated release authority. I don't have a problem with it per se. I have a real problem with it when we're talking about the 6th page of criminal history, 16 of which are hurting someone or doing something to a child or doing something to their spouse. I've got real issues with that, and I thought it best that we put those cases in front of someone wearing a black robe to let those cases be made by someone wearing a black robe. I'm good with that. I could have a different opinion, but I feel much better about public safety when those decisions, when you're at that level, are made by judges and not someone else, or not just looking at a sheet. No disrespect to anybody else. I wanted a judge making decisions for repeat violent offenders. So, any other questions for? No. All right. Thank you both. Very good. All right. That is the sum of our presentations. We've had robust discussion. Is there anything we missed or any further discussion? Representative Pierce.
Thank you, Mr. Chairman. I just wanted to make a general kind of observation for the commission to kind of consider or think about. So for me, this kind of all boils down to, our general premise that we have equal justice under law, that no matter what your level of wealth, you should be treated in the system the same way as someone with less means, and that's certainly our goal. But we kind of know that maybe that's not the reality, because, if you have wealth, you can probably hire the most talented criminal defense lawyer. You can perhaps pay them an hourly fee enough that they'll pay very careful attention to your case. If you're on the other end of the spectrum, you may end up with a public defender who has a less than optimal caseload, is having to really scramble to provide the kind of representation that everyone expects. And so that in and of itself kind of creates some inequalities. But then the things we can kind of control about these pretrial systems, we have to kind of think through the impact on the lower end of people who are in poverty. Because, for example, that middle category where there's some risk, and we've talked about things like ankle bracelets can help allow someone to be released and give the community some sense that maybe there's a little bit of protection there. But again, because we've come up with a system where we want the accused or the convicted to be paying for the system, we tell the person, okay, you can be released, but you have to agree to an ankle bracelet, and it's going to cost you X dollars a week or a month. And so if you're a person at the low end, and that's a significant burden or maybe an unobtainable financial burden, you're going to stay in prison because you can't afford the ankle bracelet. The person who has the means to say, oh yeah, sure, I'll pay for that, I'll do anything to get out of here, you're kind of covered. And I think you can have similar situations in the world of bail, right? We don't want people to be incarcerated pre-trial just because they're not a risk, but they just can't afford the bail that we might think is reasonable in general. So what I would like us to think about is, I guess we've got two things we have to balance here. We want to strive to have 0% violent crimes or new crimes while someone's awaiting trial, unattainable, but ultimate goal. And at the same time, we want this system of equal justice. And you're going to have to figure out probably which way you probably can't get the perfect balance on it. So you're going to have to, the scale is going to lean a little bit one way or the other. And so the question is, do you lean it in a way where you're maybe closer to the 0% of new crimes, but perhaps you have less equal justice? Or do you kind of go back to the old saying about, better to have 100 guilty people go free than one innocent man to be incarcerated? If that's the case, then you tilt the balance the other way toward equal justice. And so I think that's the very difficult decision that we have to make in this commission, and ultimately the legislature will have to make, and I suppose the people of the state, if they have an opportunity to vote on a constitutional amendment.
And Representative Pierce, and I agree with you. I think I'm probably at a more basic level than you are. And I'm sitting in front of a member of the court who can tell me I'm wrong, and that's fine, and I may be. But I think the way I look at it comes from our current language in Article 1, Section 17. I'm not a member of the court, not striving to be a member of the court, but if I were asked to interpret that, my opinion would be that you can't have right now preventative detention except for murder and treason. That's the way I read the code, and again, I can be wrong with people from the bench. I think there is a thought to say, well, when you're on your 16th page of criminal history and you've hurt 5 people before, shouldn't that be a consideration? And I think then where you and I to your point, then I think we get in the weeds of, well, when does that apply? And look, please know, on the first offense, I'm not close to that, right? I mean, on the third offense, I may not be there. It depends on what the offense is. I mean, you have the one-offs that somebody starts, but usually that's not the case. I mean, my experience in the criminal justice system is somebody doesn't start here. Somebody has started here and does the gradual work to get to being a knucklehead that we just can't figure out. So I think we have a basic level of, other than murder and treason, we can't hold somebody now. And I think that's what we're trying to fix. And if you look at the suggestions from last year, the recommendations from last year, I think they are very carefully crafted without getting in, to your point, of the weeds of that as to who we're really talking about. But I think that's the hard work of this group and then the legislature next year to really give some meat on the bone for the judges to know, okay, here's what we're really thinking. Like, here's who we're really concerned about. Is there further discussion? Sheriff.
The Sheriff's Association basically had 2 main points that I think we've covered very well today. One, we need a due process. We have to have a process to follow. I think talking to the 2 sides, we have pretty good skeleton of that. That makes us very happy. It gives us something we can go by. Second is still keeping some of that local control for our judiciary and for us to give recommendations. I'm sorry, I don't know how to say this. We know who our knuckleheads are, and we can speak to that. So we want there to be some discretion that our judges can have. So the minimum statewide bond is, as long as there's some type of judiciary control that they can still make their decisions off of local things, is what we like. Especially for me, a small, we know who our repeat guys are. We know their violence. We know. And we like to have that control. So, but today, and when I receive these presentations and the ISA, we're very happy to see, I mean, we're not too far off on the public defender side and the prosecutor side, and we love that, but just a due process and keeping a little bit of discretion for our judiciary locally is what we would be huge in favor of. That's all.
It's this lovely thing in the code called, and then for a consolidated city. I'll let you think about that for a second. Jared.
Real quick, Senator, a question for you, because we've talked a little bit about this statewide bail. Are your thoughts that it would be a mandatory bail until the time of initial hearing where the courts would then have discretion to alter it? Or is it just, no, this is for level 4s, it's going to be X number of dollars, period, no move? Because I'm hearing, I think, consensus that maybe some of us could live with a mandatory bail for felonies until an initial hearing, and then a judge, defense counsel, prosecutor could all make their arguments, and then it could be raised or lowered. But if it's a flat number, and especially if there's no discretion whatsoever, I'm hearing pushback from pretty much everybody. So I was just curious about what your thoughts were on that.
Yeah, I agree, and I'm not going to dare venture into speaking for 149 other people. God knows that shouldn't happen. But from where I am personally, look, misdemeanors, look, somebody that harms their spouse, somebody, I mean, I have no remorse for that kind of thing, right? But my concern, and I think a lot of our concerns, are the multiple, look, something happens to all of us. I mean, but for the grace of God, or am I? I am, and I'm certainly not casting the first stone, but somebody with one thing on their criminal history, somebody with 2 things on their criminal history, so be it. Generally I carry an expungement bill every year. I mean, I can literally put my money where my mouth is. I mean, I really believe what I'm saying, I think there's a reformative part to criminal justice, should be, and we should try to make people better on the other side. The problem that I have is that I don't know if our system's really good at figuring out. I mean, I used it. I mean, the people that are just ill-intentioned and trying to hurt people, I don't know if we deal with that very well. We certainly don't deal with it in Marion County very well from any perspective. And I can go on along. Rodney doesn't want me to, nor do you. I'm happy to go down that road with others, but we got to figure that part out. And by the way, that's probably gonna, I get judicial discretion and I want judges to have all the decision-making tools they have. I just want them to get to that point. And I think here in my home county, we weren't there. I mean, decisions were being made before it ever got to a judge. And, you know, I had police officers, and I lived next to a lot of them. And they're telling me, Aaron, I'm out arresting somebody 2 or multiple times on a shift on the same day. I mean, there's craziness that happens, and you get legislation for the lowest common denominator, and that happens to be, you know, what we're talking about here. But I certainly don't want to take away Adams County, you know, knowing who they need to address. But maybe I do when we get to a set number of arrests or a set number of convictions, or someone who has a violent, and there's a statute, I think we use the statutory code of violent offenses that we came up with last year as a starting point. I'm happy to talk about what that list consists of, but when you get to that level, that's where I think there should be some ability to say, those people should see a judge, and let Judge Spitzer decide after the prosecutor presents their side, the defense lawyer submits their side, and then let him make a good decision. I'm good with that. Anything else?
Real quick, just on that point about how crimes of violence are defined, or violent crimes are defined, my point earlier was that it's defined multiple ways in the statute. Crimes of violence has its own statute, but so does serious violent felon in possession of a firearm. And when you look, and when I tried to compare that last year, there are some on each side that I think should be in both. So that's the point I was trying to make. And I think you brought that up as well, is that maybe we need to revisit what a violent crime really means.
That's when Rodney and I get in the room and we go from there. Your Honor.
If there is some consideration of sort of statewide bail schedule or something like that, I'm wondering if the General Assembly might consider accepting out counties who have chosen to adopt an evidence-based pretrial process from a statewide bail schedule, if that's something that might be considered, given we've got some statistical evidence that what we're doing seems to be working.
I agree with you, and I'll go a step further. I mean, maybe there's a conversation that all 92, 91 courts use the system, and the state has to pay for it. I mean, maybe that's a system too, right? I'm not just saying, I'm not discounting your position at all. I'm actually saying I think it could go further, and I'm open to that. Then we just get into the finding the money for that is a real challenge, and that's just the reality of the situation. So, seeing no further discussion, Philip, who is the spokesman for this group? So,
I'm happy to be the center of the cogs of the wheel.
So, with that, any commission members, anyone who has recommendations, discussion items, please look at what we did last year in our recommendations. And look, this is not, I'm not wedded to it. I certainly don't, as much as I was giving Representative Jeter, and I love working with him, I'm not speaking for him. I don't think either one of us are wedded to what we did last year. But as a starting point, I would say that's probably a good starting point. So if you want to send Philip all of the suggestions, comments, where you want this to be, and then we'll try to circulate that as much as we can before our next meeting so that you're not looking at it for the first time walking in. The goal will be to try to get it to you maybe 7 days before, or at least the week of before. I was just, Sheriff, I love the way you think. So Philip, what would be a good time frame? Can we say submissions 10 days before our next meeting is the 29th? So should we say the 19th? Does that give you enough time to put them together and then circulate an email to everyone?
Can I make a recommendation? The 17th, because the 19th is Sunday, so could we do it that Friday before, so it gives them almost 2 full weeks?
The sheriff beat me to that one as well.
All right, there you go. You should be up here, Sheriff, doing 17th work, Zach.
Do we imagine the final report is going to recommend specific language or maybe a broader concept? I guess I'm trying to figure out like how much, how far to drill down on it.
We had that conversation last year, and I don't know Representative Pierce so well, so I'm just going to pick on Rodney only because he's used to it. That question is answered this way. I don't know how much time Representative Pierce, Rodney, I, Jeter, and any of you that are interested have to get in a room and hash out, we turn the heat up and have the 1776 compromise, right? I mean, I don't know. So I think what you saw last year was what was possible. I mean, I say in this building all the time, this building is about what's possible. And am I expecting that every one of you vote for what we put together? I mean, that'd be great, but I don't know if that's possible. So at the end of the day, I need a majority of people to vote for something. So I have to compromise and figure that out. So I would tell you, I'm happy to be as specific as we can until we lose enough people that then we don't have a majority to support what we're trying to do. So long-winded way to answer your question of it's what's possible. So with that, if you can get recommendations, comments, discussion items for by the 17th to Philip, he'll get them to everyone. We're back here on the 29th at 9 a.m. For those of you that traveled, thank you. I know 9 a.m. is not the ideal time, but thank you for the travel, and appreciate all your time and discussion. And I really meant what I said. This is a fantastic opportunity to have a discussion where everybody's shaking hands at the end of the day. And I heard Senator Pohl offer lunch, so we'll be off to lunch with Senator Pohl.